who you are.
Hey, I'm Art Leonard. I'm on the faculty here at New York Law School. I write about new court decisions on gay rights for Gay City News, and I do a newsletter on lesbian and gay law. One thing that has been happening over the past few years, a little bit under the radar of the consciousness of the public, is the degree to which gender identity discrimination is becoming covered under Title VII through interpretations, through administrative interpretations and court decisions. And I'm wondering to what extent those developments might be helpful in persuading people to support the now comprehensive version of ENDA. In 2007, Barney Frank thought that having gender identity in ENDA was a game stopper, and as the chief sponsor, he pulled it out, and ENDA without gender identity passed the House. But since then, there's been consensus among all the people who are supporting the legislation that gender identity should be in there. It should be actually in statutory law and not just depending on interpretations. But now that we've got the EEOC formal opinion, the Justice Department appellate body formal opinion, several circuit courts of appeals, increasing number of federal district courts, could this be used to help persuade members of Congress who might have particular problems with gender identity that in fact it's not going to really change things too much to include gender identity in ENDA because it's already being more expansively covered under Title VII?
Good question. Tico, I think maybe you can.
I think Professor Leonard's question is right on. It is important, first of all, for us to highlight that historic Macy versus Holder opinion of the EEOC from about 15 or 16 months ago. It was, according to a friend and colleague of mine, Dr. Dana Beyer of Gender Rights Maryland, who's also on our board, the most important transgender legal victory in the history of this country. And it is having ripple effects, you know, not just in the blue states where there are trans protections, but across the country. People are winning cases. People are able to go to the EEOC to file a complaint if they've been harassed at work because they're transgender, if they've been fired at work because they're transgender. And based on existing law in the Civil Rights Act, they're able to win those cases. And that, I think, is it's an incredibly important legal victory that we should all celebrate and that we should promote so that trans people across the country know that if something happens to you at work, if you're getting harassed or if you get fired, go to the EEOC now. They will take your complaint, they will investigate it, and they will take it very seriously. As to the politics of it, you are also exactly right that this helps us with the still undecided senators and still undecided members of the House. Because what we can say to them, and this is what Freedom to Work says to them when we lobby, I know that it's what other lobbyists say as well, is this is not a big deal. In fact, it's already law. This is just clarifying and making a uniform policy just in case some court somewhere gets it wrong. The other thing that we point out about the Macy versus Holder decision is that it was unanimous, and it was Democrats and Republican commissioners alike all voting for it. These were Republican-appointed commissioners who are Republican appointees. They are there. Oftentimes, some of these very conservative commissioners vote against workers' rights on various issues. But transgender protections have become, I think, a very common sense and bipartisan issue that regardless of party people can support. And that is hugely helpful to tout that Macy versus Holder historic decision when we lobby for ENDA, a fully inclusive ENDA.